advocate for a client, but here's the thing. He put himself in a box when he said, my client's damaged.
To get a search warrant, you have to have probable cause that a crime's been committed and there's evidence in a particular place.
Welcome. My name is Bob Bianchi from the Bianchi Law Group, and we are a team of former prosecutors that aggressively fight the government when they charge our clients with crimes. We're going to be doing an introduction into the aggravated assault statute. If you like what you hear, we're in Parsippany, New Jersey, and we practice in criminal defense, municipal court, as well as domestic violence. So please download one of our ebooks, give us a phone call for a phone consultation, or you can book a consultation online. And of course, we would love you to subscribe below. Okay, so let's get into it. Aggravated assault and assault. These are really important crimes that are not only criminal offenses, municipal court offenses, but oftentimes are involved as a predicate act, as they call it, in the domestic violence court. So it's very important to be able to understand what an assault actually is. And a lot of people think that they know what it is, but it's actually a very complex statute. For example, and I got the section of the code right in front of me because all of our laws are in a book like this called the 2C. And in that, when somebody attempts to cause or causes bodily injury to another, well, then that's a simple assault. And I'm going to break those terms down for you in a moment. And aggravated assault is much more serious. With an aggravated assault, a person is guilty if he or she attempts to cause or causes bodily injury to another, and that injury is either purposeful or knowing or under circumstances that manifest an extreme indifference to the value of human life. And there are multiple categories of where a simple assault can be elevated to actually an aggravated assault. For example, a simple assault on a police officer is elevated to an aggravated assault under the law. So how do you determine whether something is going to be a simple assault or an aggravated assault? A lot of times it comes down to the definition of what bodily injury is and what serious bodily injury is. Bodily injury is what's involved with a simple assault, and serious bodily injury and significant bodily injury are what's involved in an aggravated assault. But those definitions have code meaning. For example, bodily injury means any kind of physical pain or impairment of a physical condition, where a serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of a bodily member or organ. And then there's a middle category of aggravated assault, which is called significant bodily injury. And that's where the bodily injury creates a temporary loss of a function of a bodily member or organ, or a temporary loss of any one of the five senses. So what those things actually come down to is going to really be dependent on the facts of the case as to how serious the injury is. But if it's an injury that's very serious, it gets elevated to aggravated assault or significant bodily injury, which is also aggravated assault. And if it's just something like a slap on the face, where somebody just experiences a little pain or grab of an arm, that's going to be categorized as a simple assault. The last thing before I go to my colleagues here and toss to them is knowing the definitions of what purposeful, knowing, and reckless are. This is very important for any code violation in the criminal code because you need to have what they call actus reus, an act, and then a mens rea, a mental state. It can't just be an accident, although there are some instances where negligent conduct comes into play. But let's go to the big ones in the criminal code. The first one is a mental state called purposefully. And purposefully is where it's your conscious object to engage in that activity. If I take a gun out and I want to shoot somebody to kill them and I say, I'm going to kill you, and I fire that weapon, that is a purposeful act. As opposed to knowingly, which a lot of crimes like assault and aggravated assault also have in the section. Knowingly is when a person acts where the attendant circumstances are such that it's reasonably and practicably certain that the injury is going to result. So you don't necessarily have to have your conscious object to do it, but you're knowing based on all the facts and circumstances, it's likely that that kind of injury would occur. Whereas recklessly doesn't require really a mental state where you're knowing something or where you're doing something purposefully. But recklessly is when a person consciously disregards a substantial and unjustifiable risk. Cases like drag racing, something where it's a conscious disregard for the risk, and that risk reasonably can be calculated to cause injury. So I know that these terms can be somewhat nuanced with regard to them, but they're very, very important in terms of understanding the law. And each of those categories, whether it's aggravated assault or it's simple assault, carries varying jail time, which we'll talk about shortly. So Dave, talk to me a little bit about what you do, what you commonly see as a prosecutor or as a defense attorney with respect to self-defense, and how does self-defense fit into the assault statutes?
Yeah, thanks, Bob. And before I even get to that, we're going to put a link in the bottom where we did a video on all of those mental states that are required that could further explain, because that is critical when you're analyzing any of these statutes. But self-defense is a defense. It's an affirmative defense that a defendant can use to try to justify use of force. And it is available to defendants to rebut, to defend against unlawful force. So first and foremost, when you're defending yourself, it has to be against unlawful force. And you're only allowed to use the force if it's reasonable. And reasonable has really two prongs to it. Reasonable, it has to be objective, meaning a reasonable person would feel the same in that same situation, the need to use the self-defense. And also subjective, that person did in fact believe that the force was necessary. And then finally, if the actor is going to use self-defense, the force has to be proportionate to the force that you rebutted. All right, so self-defense is an affirmative defense in a case where a defendant can use it to justify force against another. And that is an affirmative defense that has to be pled before the court, has to be on notice, and it is a common defense used in these types of assault charges.
Thanks, Dave. Danielle, so we talked about how we have aggravated assault, which could be serious bodily injury or significant bodily injury, and then simple assault, which is a disorderly person's offense that is just bodily injury. Like I said, like that slap on the face. Can you talk to the folks about what the sentencing ranges are depending on which of those you're convicted of or plead guilty to?
Thanks, Bob. So if you're talking about a disorderly person's offense, which is that pain, that redness, that bodily injury that you discussed, that's a disorderly person's simple assault. Under that statute, the maximum jail time that you're going to receive on that is going to be 6 months in custody. That's your maximum exposure. As you go up through the assault statute, obviously those penalties increase. For a third degree aggravated assault, you're going to be looking at anywhere from between 3 to 5 years in custody. That's going to be your exposure. Now, on a second degree aggravated assault, that gets increased even more. So not only are you facing and subjected to 5 to 10 years as a max exposure in custody, you're also subjected to the No Early Release Act. So in the state of New Jersey, we have a statute in place in our sentencing guidelines for certain violent offenses. Second degree aggravated assault is one of those offenses. So therefore, you are subject to, as I stated, the No Early Release or the NERA Act, where you have to serve 85% of that sentence. So if somebody is charged with a second degree aggravated assault, and if they receive a plea deal of 5 years in New Jersey State Prison, that's going to come with an 85% period of parole and eligibility, where that individual will not be eligible for parole during that time. In addition to that, after they are finished with whatever jail time that they've received on the second degree aggravated assault, you're also exposed to a period of parole supervision after that for up to 3 years after you're released from incarceration. Bob.
Okay, great, Danielle. And as we talked before about the varying different kinds of injuries, we also talked about the mental state that was required. So that little refresher, it could be purposeful, it could be knowing, it could be reckless, and there's a little category there for negligence. You really don't see that much. Kayla, our appellate guru, argued before the Supreme Court 6 times. Talk to me a little bit about what it means in the statute where I was reading before. It says attempts to cause or causes serious bodily injury or significant bodily injury, or attempts to cause or causes bodily injury. What does this attempt thing mean?
So attempt essentially means that if you swing and you miss, you can still be charged with assault or aggravated assault, depending on what the bodily injury might be. So with an attempt, you're looking at the circumstances surrounding the situation. Because you didn't necessarily connect that punch, the prosecutor has the burden of proving that you were intending and that you were taking a substantial step towards assaulting the other person. So it might be the words leading up to it, the argument. It might be somebody saying, look out, he or she is taking a swing at you. It's these sorts of things that are used to show that you attempted, but you didn't quite land the punch, and that would still constitute an assault through the theory of attempt under the 2C.
Attempt has to be purposeful, that mental state that we were talking about before, which is that that's your conscious object to do it. And sometimes for prosecutors, that not sometimes, it always is the hardest thing to prove, because a lot of times you don't have direct evidence of a person's purpose, what their state of mind is. You have to infer it from other facts and circumstances. So, and every attempt, it's not negligence, it's not reckless, it's not knowing, it's purposeful. Every attempt has to be purposeful. Big point. Dave Bruno, do me a favor, bring it home, tell people where they can find us and like us and all that kind of good stuff.
Thank you. If you like the video, give it a like, subscribe to our channel, the Bianchi Law Group YouTube channel. We are frequently putting out videos like this on substantive crimes, legal issues, developing legal issues, both in New Jersey and nationally. Bob Bianchi and I are both national legal analysts, and we appear regularly in the national media. We are a team of former prosecutors that aggressively fight the government when our clients are charged with crimes. We handle criminal defense, domestic violence, municipal court, and appeals. You could find us on our website, bianchilawgroup.com. You could find us on Twitter, Facebook, Instagram, Google+, LinkedIn, basically everywhere. We hope you found this content and the content in the description valuable, and we thank you for watching.